Good afternoon. On behalf of the Asian Institute of International Financial Law, AIIFL, I'd like to extend our warmest welcome to you for you to join AIIFL's book talk today with an enlightening title, Regulating the Crypto Economy, Business Transformations and Financialization. My name is Emily Lee. I'm the director of the AIIFL, which is housed at the Faculty of Law of the University of Hong Kong. My co-host today is Associate Professor Dora Neal. Dora is the director of the Center for Banking and Finance Law, CBFL, at the Faculty of Law, National University of Singapore and US. In this regard, it is worth noting that in the acknowledgement of today's featured book, Professor Chiu has said, and I quote, "I also thank the Center for Banking and Finance Law, National University of Singapore, which hosted me in February to April 2021 as I was finalizing this book," end quote. It is therefore quite meaningful that today's event is jointly hosted by the two research centers, the AIIFL at Hong Kong U and the CBFL at NUS. It gives me great pleasure, and it is indeed an honor and privilege for me to introduce our very distinguished speaker, Professor Iris Chiu, and her discussant, Professor Kelvin Low. Professor Iris Chiu is Professor of Corporate Law and Financial Regulation at Faculty of Laws, University College London, UCL, in London, England. Iris is a prolific writer and one of the most critically acclaimed academics in her field. Prior to joining academia, Iris was a legislative draftsman and state counsel at the Attorney General's chambers in Singapore. In the past 5 to 6 years, other than her journal articles and her most recently published book, Regulating the Crypto Economy, on which today's book talk is premised, Iris is the author or co-author of 2 other leading books, A, Corporate Governance and Investment Management, The Promises and Limitations of the New Financial Economy, which was published in 2017, and B, Regulating from the Inside, the Legal Framework for Internal Control in Banks and Financial Institutions, which was released in 2015, along with a textbook, Banking Law and Regulation, which was printed in 2019 by Oxford University Press. Her discussant today is Professor Kelvin Low at the Faculty of Law of NUS. Kelvin's research interest spans the field of private law, but with a particular interest in property. Kelvin's work on crypto has interfaced with the private law and appeared in leading journals such as International Comparative Law Quarterly, Law Quality Review, and Journal of Equity. As an advance notice, AIIFL will have the pleasure of hosting a separate webinar for Professor Low on the topic of blockchain asset registries, freeing crypto from mania. Details of the event will be announced in due course. Please stay tuned for that. The rundown of today's event is as follows. After Professor Chiu introduces her book, her discussant, Professor Low, will take over to share his thoughts and comments about the book. We'll leave about 10 minutes of the Q&A time by opening the floor to the online audience to generate more interactive discussion. For that purpose, I would ask the audience to please type questions in the chat box. I will now invite Associate Professor Dora Neal, who is the director of CBFL at NUS, to speak a few words as her welcome speech. Thank you.
Thank you so much, Emily. Good afternoon, everyone. This is Dora Neal, and I bring you greetings from the Center for Banking and Finance Law at the Faculty of Law of NUS. Welcome. It is a great pleasure for CBFL to join with the Asian Institute of International Financial Law at Hong Kong U to host this book talk by Professor Iris Chiu with Professor Kelvin Low as discussant. As Emily has said, CBFL was very happy to have had Iris with us as a visiting research professor when she was completing the last part of her book in the first half of last year, the book Regulating the Crypto Economy. It is an interesting and illuminating read, and I'm sure that you're all looking forward very much to hearing what Iris and Kelvin have to say, and I wish you all a very pleasant afternoon.
Thank you very much. Without further ado, I'll now pass the floor to the speaker and author of today's featured book, Regulating the Crypto Economy. Over to you, Iris. Thank you.
Thank you, everyone. Thank you, Emily, for your very kind introduction. Thank you, Dora. Thank you especially to CBFL for hosting the last few months of the finalization of the manuscript and for hosting a couple of seminars for me to discuss the book. Obviously, I'm not holding CBFL responsible for any of my views. All errors and omissions are mine, and the usual disclaimer applies. And I thank Kelvin too for taking time to discuss this book and to also read it because it ended up being rather long. But I still hope to be able to enthuse everyone as far as I can regarding the messages that I want to send via this book, which I think ultimately reflect a pet project of mine, whether or not you agree with all of it. And of course, there are certain limitations with regard to the book. So thank you all for being here. And I think I will try and share my screen. I think I might not have permission to share my screen. It's not coming up. I'm just wondering if the administrator might be able to fix this.
Okay,
or share my
let me try.
slides.
Let me try. I should be able to do that.
Right. Yes, if you could bring it up to the first slide, I think that would help. Right. Thank you, Emily. And I'm sorry to make you do this for me in terms
no problem at all. Pleasure.
Right. Okay, so basically, I'm introducing the book today, but I'm not going to go into great detail as to how everything is reasoned. I think there is a place for reading the book as well as the full reasoning behind some of the suggestions. Next slide, please, Emily. And as Dora has showed, this is a picture of the cover of the book. Unfortunately, I had to fall in line with Hart's design for the series in commercial and financial law, so nothing fancy could actually be put on the cover. So it is quite a boring cover as it looks, but hopefully the contents inside would be more exciting. Next slide, please, Emily. Right. Yeah. The full brickwork. What I'm going to talk about today would be first what motivated the writing of the book. I think if an author sets in context the motivations for writing of the book, it probably explains better the messages within the book. And I will also present some key teasers in the book in terms of what were the areas that I saw were most pertinent for regulatory policy and reform. And I would also talk a bit about the legal frameworks that I think ought to be in place, comparing with existing frameworks as well as their limitations. And finally, I would also talk about the limitations of the book, as well as what else I would have liked to do. sorry. I mean, this area of crypto has developed very rapidly, and the book has a cutoff point for manuscript delivery. So there have been developments that the book would not have been able to fully account for. Next slide, please, Emily. So what motivated the writing of this book? I think when we think about the crypto space, much attention has been focused really on the financial aspects. I mean, we see the crypto space largely through a financial lens. We look at the currency developments, we look at stable coins, and this is all very real and very pressing, as the Financial Stability Board has recently become a lot more overt in its policy position. However, I think one thing that attracted me to this area, other than all of the financial aspects, which I research in intensively, are the entrepreneurial aspects. I mean, there are some innovations that are offered in the crypto economy, a space which I define as economic activity taking place in permissionless blockchains. And the book focuses largely on the Ethereum blockchain. And I see some innovations and some peer-to-peer activities, commercial activities that are genuinely very interesting. And so I come to this from the point of view of there is entrepreneurial and enterprise elements there that are really rather valuable. And so being pro-innovation myself, I'm interested to see what actually is going on that deserves and requires financial support, because finance doesn't stand on its own. And I often, and I think it's not just me, many financial regulation scholars would see finance as going alongside and helping the productive economy. And so although the crypto economy produces intangible things, it is nevertheless productive in that sense. And from my point of view, I see regulators as playing a part not just to inhibit or to control the excesses, the problems that we know are taking place in the crypto economy. So as far as I acknowledge and I know that there have been issues of illegal activities, money laundering, ransomware problems with the crypto economy, particularly with regard to Bitcoin, the crypto economy can be described as a field of rather murky waters, but yet there is a baby in the bathwater. And so the message of the book really is to try and save that baby, to basically see what is it about the qualities of innovation and entrepreneurship and mobilization that can be saved and should be and should be facilitated and enabled. And I think that point of view is rather important. And with that point of view, then perhaps financial regulatory policy can fall into place in terms of its proper location alongside entrepreneurship, while providing a certain governance order that is institutionally compatible and credible. So I don't see regulatory policy as merely being inhibitive towards innovation. And I think this is consistent with the political theory of regulatory capitalism. And regulatory capitalism often sees that market economies are supported by regulation, that commercial activity can flourish and be steered by the private sector. But regulation does come alongside to govern the excesses, to address market failures, and also to provide overall the public and the collective goods that are needed by economic participants and actors. And so regulatory policy can play an enabling and facilitative role. And this book intends to argue for that sort of balance, that we are looking at governance aspects of regulatory policy, but very much in a way that supports the facilitative and enabling aspects that can be relevant for the crypto economy. And because my areas of expertise, as Emily has introduced, are in corporate law and in financial regulation, the book inevitably focuses on regulatory policies that are relevant to these areas. There are, of course, other areas beyond what I can discuss here as well as in the book, but I hope to be able to at least provide that slice of the perspective. Next slide, please, Emily. So in terms of the financial lens, which many people are very interested in, it is important. And although I have said what I wanted to say earlier regarding the importance of entrepreneurship and how I see that as underpinning my interest in the book, but the book acknowledges it very overtly that crypto economy developments have been wrapped up in financial framing. And that is adopted even by the crypto entrepreneurs who are out there. And there is good reason for it because there are genuine needs in relation to fundraising. Of course, in terms of fundraising, there are scams and there are genuinely interesting projects that people are exploring. So this is, again, a very balanced space in terms of there is a baby in there, but there is also bathwater, which we don't want. But at the end of the day, can we discern what is good and be able to enable and mobilize what is good? In terms of the financial framing that is relevant so far, this slide kind of stock takes what we are familiar with. One is cryptocurrency, and the famous one is Bitcoin. But the book does focus much more on Ether as being the native currency of the permissionless blockchain Ethereum. And I think the Ethereum blockchain is quite undisputedly the largest space for economic activity taking place on a permissionless blockchain. I mean, there are virtual goods that are being sold and bought on the Ethereum blockchain. There are virtual peer-to-peer services that are being developed. So in terms of an alternative peer-to-peer type of economic space, the Ethereum blockchain may represent a mini alternative universe. And in that universe, the currency of the system is Ether, but that is also because that is programmed as the native token of the blockchain protocol. So in that way, we are seeing a growing, kind of decentralized, connected private monetary system. Besides Ether, of course, itself being subject to volatility and therefore being seen as an asset for investment. The other financial framing that has been rather important is fundraising. And that is associated with the initial coin offering hype between, I would say, kind of 2017 to 18. That was the height of ICOs until the US Securities Exchange Commission clarified how they saw ICOs in light of the application of securities law. And since then, fundraisers have taken rather different approaches in relation to fundraising. But during that a kind of unregulated period where ICOs mushroomed, we saw a lot of attention placed on how much, in US dollars was raised by this or that project. However, what is really important is what the projects would actually become. And these projects are decentralized applications, usually on the Ethereum blockchain, and the convenient shorthand we use for that is dApps. And I think it is what the potential of the projects would be, what the promises would be that interest me, that fundraising ultimately goes towards the realization and the fulfillment of these projects. And if these projects are successful, then they can stimulate different forms of peer-to-peer commerce and enterprise, which can be very interesting. And my next slide will be able to show a few examples of what I have found to be, rather interesting and impressive. But at the same time, I think there are continued financial developments necessary in the crypto space, which developers have seen as necessary to support some of the deficits in the self-regulatory system, such as stable coins. And of course, stable coins do raise certain issues which the book does discuss. And recently, we have seen non-fungible tokens but I would say non-fungible tokens are an extension of the commercial possibilities on the Ethereum blockchain, and they can be very empowering for people who do digital art. And if we look at existing market channels for artists, being able to go peer-to-peer and sell art directly, for example, can be very empowering. But of course, NFTs are, also being financialized. So we are looking really at kind of the center of the book is the interest in entrepreneurship, but paying a lot of attention on the financialized framing and on the needs for finance, and hoping to find a regulatory order that is suitable for this phenomenon. Right. Next slide, please, Emily. Thank you very much. I would like to share some of the interesting aspects of the entrepreneurship kind of developments that I saw that interested me. And these are 3 dApps that I think are still in development. It's not as if they don't have problems, and they also have subscribers that I felt were really rather interesting. And we could, turn our attention to them and not poo-poo them, I would say, because, at the beginning of the internet economy, none of the search engines that I used, in the early 1990s survive, post Google. And if no one thought that search engines were of any potential, then we wouldn't have Google. So in other words, I think if we keep an open mind about what these could do, then we might be able to see new entrepreneurialism, coming into place. AIIFL is a very interesting dApp. I mean, the idea is to have many individuals connect up their Wi-Fi facilities to a peer-to-peer network. And these Wi-Fi facilities, when they're idle, they can then be commoditized and sold to people who may want to access the internet on the go. It is, I think, particularly useful for people who are traveling and who are maybe in a city for a day and suffering, huge mobile data charges just to access the internet. I mean, if you're a member of AIIFL and you're able to borrow the Wi-Fi facilities of someone on the network in the foreign city you are in, that could be a cost-effective way of getting internet coverage. And if there is worldwide coverage, if it becomes a credible, seamless system, it could be a really rather useful utility. So I was attracted to this idea, but I also know that there are huge problems in terms of constructing this network. And Filecoin is a decentralized peer-to-peer cloud storage service. And that allows us an alternative from Amazon or Google or Apple in terms of centralized cloud service providers. People could enjoy a service in Filecoin by having their files sharded or what we call sliced up by the automated protocols in Filecoin. And the files will be stored in multiple copies without losing their privacy with the nodes on the network. So without a single point of failure, this could be a reliable cloud system using peer-to-peer spare capacities on their computer. And the third one, Golem, is a peer-to-peer power processing service where computer power or spare capacity can actually be shared amongst the network so that people who need a certain boost in power, for example, for graphics work, could be able to rent such power from the network of peer-to-peer sharers. So some of these ideas, I think, are not completely fantastical. I mean, they do sound rather plausible to me, not to say that they wouldn't face difficulties in their development. Next slide, please. So in terms of promoting entrepreneurialism, I think regulators do need to help in terms of sifting out the wheat from the chaff as well, because with the hype, especially in fundraising for ICOs, and the book was conceived at about that time, which is why there is quite a lot of focus on fundraising and on crypto assets. I see regulators as playing an enabling role in that. so that the hype is not merely taken advantage of by opportunists who don't really actually have a business idea that is susceptible to being deployed on a permissionless blockchain. I think many peer-to-peer services make sense on the permissionless blockchain only if the distributed power and the decentralized framework actually multiplies and provides an exponential, addition to what a centralized provider can do. So there are certain efficiencies, there are certain capacities that may be better provided decentralized and distributed than centralized, and that should be what guides us in terms of looking at kind of efficient compatibilities with the permissionless blockchain. The Financial Times ran a story about a failed ICO called Sponsy. And it basically was a young entrepreneur who tried to flog an ICO at the time of its height to fundraise for a DApp that would collect charitable donations, at kind of a one-stop shop, and then distribute them to charities that would sign up to its network. But this ICO failed. It actually wasn't supported by the masses. And the young entrepreneur then wanted to flog the business development documents on eBay for a few $1,000s. And the Financial Times picked this up and ran a story about, basically disingenuous schemes that tried to take advantage of the ICO hype. But on the other hand, I think we can take comfort in the fact that the market did not support this particular scheme. So people in the market are not completely that undiscerning. There is a particular wisdom of the crowds as well. But there is a role, in terms of regulatory policy, promoting viable blockchain-based businesses while sifting out those that are, not compatible or not suitable. And so I see that we can have a regulatory agenda that is enabling in that way. Can we have the next slide, please, Emily? Right, so the key teasers in the book, one central pillar of the book is that we talk about, or I've talked about blockchain enterprise laws, whether we need a new organizational enabling enterprise structure for the blockchain-based business, basically for the dApps, the decentralized applications, and whether there might be a meaningful role for regulatory competition too amongst jurisdictions that are trying to develop this area of laws. And secondly, the book does talk about fundraising laws because it was conceived at the height of the ICO boom. And it looks at the SEC's enforcement and really, I think, a mere extension of existing regulatory frameworks can be over-inclusive in nature. And so the bespoke approach that is being taken in the EU is something that I think is along the right lines. However, the book proposes a different approach from the Markets and Crypto Assets Regulation, the MiCA. And I also think that if because of the SEC's enforcement action, a lot of fundraisers for new crypto dApps have gone down the route of Regulation D or going private. And the nature of these financiers also shape the nature of business development. So we do have to think about how finance might shape entrepreneurialism and whether it is ideal, for that to take place. The issue of private money and payment systems is one that has always loomed large. We do see the open permissionless blockchains as being unregulable to a certain extent. The book tries to grapple with that to see how we might introduce certain standards even if we cannot regulate in the same way. And finally, the book, during my period at CBFL and NUS, I was finishing up DeFi, which we know is a decentralized finance, has a lot of promises for people, but often seen as speculative, hazardous, and socially unproductive. I think there are certain uses and purposes for DeFi, but DeFi does raise certain hazards. Does it really defy financial regulation? The FSB does not totally think so, and I don't think so either. Right, the next slide, please. Right. So in terms of legal frameworks discussed in the book, I do talk about different forms of organizational laws, as well as certain pioneering templates attempted by small states at the moment to enable blockchain-based enterprises. I think these are interesting, and I think that there can be more regulatory attention on the enabling aspect of allowing blockchain enterprises to be recognized differently, and perhaps, you know, to enable and facilitate some of the governance structures. The book discusses an extensive amount of financial law and policy as well, and I think that is only to be expected. I do propose a slightly different framework for fundraising from the EU MiCA, but I think the EU MiCA has taken the right step forward to provide a bespoke, tailor-made regime for crypto assets, which is different from just extending the existing regime. And I think that that is preferred. The fundraising chapter is rather long, and it also deals with the self-regulatory mechanisms that ICO founders have already put in. And so it deals with basically bottom-up mechanisms comparing with what can be achieved in regulatory policy. In terms of payment services, I think that there is scope to think about how code can be embedded to basically reflect certain basic standards that we care about in payment services, mainly, you know, certainty for users as well as anti-money laundering. And I think that aspect really does need to be addressed. But we probably cannot prevent the competition of private money. Obviously, central banks know that, and there is a lot of discussion on the CBDC, the central bank digital currency, which is a different topic I'm interested in and on which I've worked. Finally, I mean, the book provides high-level thoughts about DeFi. I think by that time, when DeFi started to gain traction, the book was close to its manuscript delivery. And so the final chapter on DeFi was quite high level, but I hope that it remains useful and pertinent in terms of looking at what are the purposes DeFi serves and what are the purposes, you know, and objectives we want to achieve in regulating DeFi, if we can, and in whatever terms. Next slide, please, Emily. So in terms of the limitations of the book does have a lot of limitations. It doesn't deal with the users of blockchains in general, especially permissioned blockchains. It really, I would say, fairly focuses only on the permissionless Ethereum blockchain. And in terms of the sort of economic space it creates for alternative commerce and entrepreneurship. It is a book that does not seek to merely apply existing financial law or regulation to crypto developments to see what financial regulation in its existing framework can catch or capture. So it is not oriented in these terms. It does talk about the limitations of existing regimes, but I think it focuses quite a lot more on what can be done, the normative positions and the regulatory reform. It is also not the book that engages excessively in private law, assuming that private law provides, you know, the default framework for market order and for serving market participants' needs. I acknowledge the really importance of private law, and I mean the case of AA and Bitfinex in the UK shows how very clearly how private law has been used to achieve a very important public interest purpose. And so private law does have its space, but it is not my strength, and therefore this is an area that I'll benefit from learning from Kelvin, who will speak after me. And finally, the regulatory policy covered in the book cannot be, you know, completely extensive either. I focus on corporate/organizational law, financial law, and regulation. But I acknowledge and know that competition law, digital and data regulation, consumer protection laws would be extremely important aspects as well. And I'm sure that there is a vast amount of literature out there that covers these that I don't. So these are some of the limitations of the book, and there might be more, and I do welcome feedback and comments in this respect. Next slide, please, Emily. So what else I would have liked to do is, I do think of the permissionless blockchain space as being a virtual world, and perhaps there could have been some scope in framing virtual world, economic activity, including sort of gaming type virtual worlds, and how all of that adds up in terms of a new economic space, and how that should be theorized, how that should be discussed. So I think there is scope for a larger and alternative sort of framing, which the book hasn't actually taken. I'm very interested in the development of non-fungible tokens, not just from the point of view of what it is, which is already subject to a lot of debate, but also in recent developments in financializing non-fungible tokens, even before we have really determined what they are. I'm working on a paper with a joint author. This is a paper now under consideration on the financialization of NFTs and how we see that going forward. So hopefully, we are continuing to contribute to this area even after the book has to be closed. And finally, I would really like to know how the extension of existing regulation has affected the entrepreneurial kind of developments in the permissionless blockchain space. Has the fact that certain financiers are regarded as permitted within this space changed the shape of entrepreneurship, and in what way, and for the better or for the worse? This is something that I'm really very interested in, which possibly has to be found out by empirical research, and I think that sheds light generally on what regulatory policy can do, for better or for worse. Final slide, please, Emily. Thank you. And so concluding thoughts is, I hope that this book may contribute to policy thinking and discussion. I know that policymakers often see academics as useful resources, but sometimes as eccentric or bohemian. And we may not be taken seriously, but I think many of us do have certain messages that we see and we are quite impassioned about, and we hope to contribute to that discussion. And I think let's not give up on seeing the enterprise potential in the crypto economy, even though we are well aware of all the other problems that need to be solved, the hazards, the evils that we hear about. And by no means am I saying that these are not important. And the book does deal with some of these, especially in the space of anti-money laundering. And finally, I think financial regulators getting their hands on regulatory policy for the crypto economy presents a hazard to us. And that is regulatory policy can be quite narrowly framed. I think there is a need to holistically consider the importance of the connection to enterprise and to innovation. So that's all I have for you. Thank you very much. I probably have gone way over time because I'm not actually timing or monitoring myself, but I really look forward to listening to Kelvin and to receiving questions. Thank you.
Thank you. Kelvin, can I invite you to make your comments? Thank you.
Thank you, Emily, and thank you.
Do you have, yes, I do have.
I have no slides.
Okay.
Yeah. Sorry.
No problem. No.
Thanks, Iris and Emily and Dora for having me as a discussant, despite my complete lack of knowledge on the regulatory aspects of law. So my background is pretty much private law, so with a heavy focus on property. I kind of got into crypto by accident, probably around the same time as Iris. And so I do know the tech, I would say, fairly well, but I am quite the novice in terms of how to regulate, the objectives of regulation, and that Iris is definitely the expert. I think she has been far too modest in terms of describing the scope of her book. I mean, it was written in little more than a year. I couldn't have written this in anything less than twice the amount of time, right? So very, very impressive scope. I've learned of projects that Iris covers that I didn't know of, and I've gone down this rabbit hole quite far. I guess I want to discuss a couple of things. I will touch a little bit on private law since Iris has suggested that I might do so. But before I do that, I just wanted, Iris's approach has been to try and suggest a bespoke regulatory framework for almost every aspect. Because I think Iris takes the view there's a baby in this murky bathwater and we don't really want to throw out the baby together with the bathwater, right? And I guess one question I have for Iris, hopefully she can answer during Q&A, is because there is a cost in terms of the time of the regulators in learning how special this place is, and in drafting out this new regulatory framework, right? At what point is it worthwhile for this time and effort to be spent in coming out with a bespoke framework, as the Europeans are doing, versus using perhaps an existing framework, as the Americans are doing, because some of the concerns that the existing framework addresses are similar to what we see, right? So what are the concerns in the ICO space? Well, basically the financialization. So people buy in the hopes of offloading it onto someone else, right? And all the ICOs that I have seen all market themselves on the basis you come in today, it's going to be cheaper, it's all going to increase in value. So it's a fairly similar concern, not just to IPOs, but any kind of crowdfunding really. So Kickstarter, Indiegogo, going back even as far as off-plan purchases for land, which was of course invented in Hong Kong. Right? The idea was you buy today, it's going to be cheaper than you buy tomorrow, which then gets this whole fear of missing out momentum going. So to the extent that the public offering framework addresses this concern, it may not be perfect for this new economy, but we can shoehorn it here, right? So to what extent, when do we decide that it is worthwhile to put in the time and the effort, right? Because crypto is a very interesting thing, right? There's been a lot of excitement since about 2014. That was, I think, the first hype around the time when Mt. Gox got hacked. But if you look for actually socially productive users, I would say up till today, it's mostly been in either sandboxes or theoretical. So it's got a very different trajectory than innovations, other kinds of technological innovations. So if you look at how tech innovations tend to play out over time, the usual story goes, there's this euphoria, right? Where there's widespread adoption, tremendous benefits, and then suddenly you start seeing the problems. So give you two examples, right? The motor car, right? Which of course took the place of horse-drawn carriages. Faster, no more horse shit all over the roads. But then over time, you start seeing the problems, right? Traffic accidents, deaths, so that's one example. The internet is another, right? So when the internet took off, initially it was all, it's going to bring democracy around the world, freedom of speech, and so on and so forth. Now we start seeing all the downsides, right? So crypto is strange in the sense that we've seen a lot of the downside, but actually in terms of socially productive users, I haven't really seen very much, right? A lot of it's been theorized, so peer-to-peer file cloud services, for example, Filecoin, so the interplanetary file system. But the IPFS, despite lacking so-called a single point of failure and arguably protecting your privacy better, is a much, much slower service than a centralized server. And you can still lose whatever is in that IPFS cloud. As if you look at the NFT space, because a lot of the NFTs use the IPFS, right, to store the artwork. On multiple occasions, people have found that the IPFS links have failed because perhaps one or multiple shards are unavailable, right? So there's a lot of theorizing of the benefits of decentralization, but actual productive use today, not so much. Again, there's a lot of comparison between crypto and the internet, but you see, again, very big differences. If you look at the trajectory of the internet, within a year of ARPANET being deployed, ARPANET being the precursor of the internet that was developed by ARPA in the US, email was a killer app, so to speak. And the World Wide Web, within 2 to 3 years of the World Wide Web being put together, you had e-commerce take off, right? The blockchain was introduced in 2018. 2008, the Bitcoin blockchain came live 1 year later. Up until today, no real use other than speculation, right? So I'm wondering, given that there isn't this available evidence of productive use, how far should we go bending over backwards to create a new regulatory scheme, which may not work as well? Okay, so that's something I would like to hear from Iris on. Now, in terms of the private law aspect, and this is also something, I don't know how it interfaces, if it does, with regulation. One of the problems with the blockchain, it's meant to be immutable, right? Now, immutable doesn't really mean what we think it means. You can change the entries in the ledger. It's just harder, right, as time goes by. And the problem with trying to use the law to get the ledger state changed is not so much immutability, it is more the fact that it is distributed, right? So court orders don't work because there's no centralized registrar. Normally, if you want to rectify a mistaken record, you just go after the registrar, get a court order against the registrar to correct the wrong entry, and there will always be wrong entries, right? The blockchain does not prevent errors, right? All it does is perpetuates them. So this leads to a problem. So Iris mentions Edmund Schuster's paper in her book. Edmund is another crypto skeptic like myself. And our fundamental problem with the technology is this, okay? If you don't put in to the blockchain code a power to rectify the code from a centralized authority, whether it's the courts or someone else, then it becomes very hard to correct any errors, right? Whether the error is the result of fraud or just silly mistake. So this means that at some point, because all these records record something, right? Usually a right, a legal right, whether it's a legal right to services, a legal right to art, whatever it may be. You lead to essentially a fork between the legal position and what is recorded on the blockchain ledger. Now, if it can't be corrected, then the ledger basically just gets increasingly useless. Now, if it can be corrected, right, then that raises a question. I mean, the whole excitement of the blockchain is there's no single point of failure, right? But if somebody has the power of correction, then you have just reintroduced the single point of failure. So the choice seems to be between using a technology that is fundamentally useless because it cannot keep up with what the legal position is, and you can't code for it, or one that is pointless. Because if you've just reintroduced a single point of failure, why not just use a centralized service, right? So that is the conundrum that I think some of us skeptics have. It's not so much that the technology will not scale, is that there's this fundamental problem. What happens when something goes off, in the ledger that doesn't match the strict, correct legal position, are we going to change the law? It would be very harsh if we started changing the law. No legal system I know of simply goes that, oh, you have a ledger and whatever it says will be gospel, right? So that, I think, is a conundrum that I don't know how it interfaces with regulation. Is IRIS proposing that the regulation not have to deal with the state of the ledger and simply address the people involved, so the coders, people using it? Or is this important? And if it is important, how can this problem be solved? Because to me, it looks insoluble. Now, finally, just a small point about DAOs and separate legal personality. I mean, IRIS has suggested that we confer upon DAOs separate legal personality. This is the idea of extending company law, where companies are given separate legal personalities to DAOs. It is not peculiar to DAOs. It's been suggested in the AI space, right? That we start conferring separate legal personalities to artificial intelligence. And I suppose my concern there is this, right? There is a fundamental problem with separate legal personality, even in the context of company law. It attenuates a lot of our criminal law sanctions, right? If you look at, for example, all the kind of frauds that led up to the global financial crisis, very few people have been held accountable. And a lot of it is because a lot of these activities take place behind the separate legal personality, right? Now, so I am very wary of extending separate legal personality before we crack the puzzle of how do we solve the problem in the context of company law. So before we extend the problem outside of company law, whether it's to DAOs or to AI, perhaps we need to take stock and deal with the problems as we find it today in company law. And if we solve it, then I am a lot more relaxed about extending it beyond the company law space. So I think I will stop there and leave time for Q&A.
Thank you very much, Kelvin. You have given us a lot of food for thoughts, and just to answer your questions alone, we probably will run out of the Q&A time. So I will actually leave the discretion to Iris. On top of the questions that raised by Kelvin, there are at least two more questions that I can see from the audience. One is from our friend, Professor Ruth Plato-Shina. She asked questions about private money and payment services, whether your book actually referred to consumer protection. So there was basically one question. And the other question was also raised from an academic, a professor from PolyU Hong Kong. The question was about anonymity culture in the crypto world, including DAO. And I think this is something that Kelvin has been raised as well. So I'll just leave the questions with Iris or Kelvin. Yeah, thank you.
Thank you, Emily. I can see that there are actually quite a lot of questions. I think six in total, or seven from many friends. And so, could I just greet everyone and say hello to Ruth and Yanto, as well as Andrew from Australia. Thank you all for being here. And hello to Mark McKenzie, as well as Tobias, Jenny, and Ron, who have asked questions. I think I won't be able to do any justice in the amount of time that is left. Hopefully, basically, I think one thing I want to say with regard to Kelvin's questions, I think maybe I'll just make one point, is that the crypto skeptics do look at blockchain as being it is not really efficiently or effectively decentralized. So why have it altogether? An all or nothing approach can be a way of looking at things. However, between centralization and decentralization, there is a spectrum. And perhaps where we are at with the blockchain is an experimental position towards, as much as is possible, fully decentralized and effective, but not really getting there. And this is why we have interventions from the Ethereum Foundation, for example, and from miners who choose to fork the ledger when there is a problem, such as a hack. This is a work in progress, and I think works in progress. Maybe I'm the optimist rather than the critic at the moment. I think works in progress should be given a chance to develop, and we might in the end arrive at a position where this tends towards decentralization with certain effectiveness in automated protocols. And we may then find that certain automated protocols may work better than others. So the permissionless blockchain decentralized structure doesn't suit every type of commerce, but it could well be that it suits some better than others. And so that exploratory process is the thing that I don't want to preempt. So hopefully that covers a lot of questions that people are asking. So in other words, this is not inconsistent with having regulatory policy, which is in a way a centralized institution, because you're not fully decentralized anyway on permissionless blockchains. And there are certain issues to sort. They are the same old market failures as well. But what we are looking at is a commercial phenomenon that tends towards decentralization, that's all, with hopefully better and more effective automated protocols that fit certain types of commercial offerings. So we are looking at finding the optimality rather than saying that all of this should therefore be junk or it is all not useful. So that's where I differ, I think, from Kelvin's position. But Kelvin has great points. And I also hope that by saying that, I have addressed some questions in the Q&A regarding the roles of centralized authorities and how they can interface, with this environment that seemingly looks to be, anomalous or contradictory. In terms of the exact types of legal institutions, that there are a few questions in the Q&A that are picked up on that are interesting. I think Ruth's question on consumer protection, I very much agree with that. And the payment services chapter does look at how consumer protection can be offered. And I would say that developers are in the loop as well in terms of providing a certain level of consumer protection for those that use the permissionless blockchain to transact in their commercial activities. And so rather than consumer protection offered in the same sort of centralized standards and being policed by regulatory agencies will probably be in a more decentered space with providers of services themselves having to take on certain responsibilities. And that providers are, in a way, a point of centralization. So therefore, there is no real complete decentralization anyway, I think, in a commercial blockchain space. I am worried about excessive amounts of anonymity that may facilitate illegal activities as well. I think it's a difficult thing. I think one BIS economist, whom I've cited in the book, has proposed a sort of embedment of code into, with regulatory policy, with regulatory standards. It does require regulatory agencies to be open-minded and to be able to work with the protocol developers who are, for example, in the Ethereum Foundation, for example. There are lots of miners who are dispersed, across different geographical locations in the world. Some of them are in jurisdictions with structures and cultures that are very different from the West. So it is difficult to get this conversation going. And I can see in theory how it would be good if people are much more joined up and much more diverse and open-minded in terms of how they seek knowledge and resources in building up this area of learning. But I do see the difficulties. On blockchain enterprise law, I would say I looked at Vermont as well as the Maltese legislation. The Maltese one has gone, I think, the furthest in terms of how they see an innovative technological arrangement, which is blockchain or DAOs or other versions of DAOs operating and under what circumstances they would authorize, such an organization. They need to find responsible kind of code developers and technological administrators in order to be part of the regulatory regime. The Maltese regime is a starting regime, It probably doesn't have all of the answers, and I also critique that regime in the book, but it's a good starting point for us to think about the exact organizational needs of such a kind of loosely formed and differently structured peer-to-peer, arrangement. It requires different thinking. And although I look at it from the point of view of being able to benefit from separate legal personality, because people participating in a structure have something in common that they do not necessarily want, to spill into their personal lives, but separate legal personality can be itself a problem, and it could be something that we reform upon rather than extend from, what is existing. And why do we not extend from what is existing? I think if we look at why we have mobilized crowdfunding, crowdfunding is still quite a small industry, but we still have decided to mobilize it. There is some value in promoting and enabling innovation, the benefit of which you may not be able to totally account for. And I think it's the optimism and the hope in that drives such policy, so that we are not merely looking at counting, quantitative cost versus benefit, but we are looking also at human aspiration and how do you calculate and count that. And so I think hopefully, within time, I've said as much as I can with regard to the insights, the questions, the comments posed by the audience. And I'm very thankful for so many who are here today. Thank you all very much. And let me hand back to Emily.
Thank you. Thank you, Iris. You did make use of the Q&A time, very limited time given to you with number of questions projected. You did use your time very, very well. And thank you very much for your very informative and enlightening public lecture today in the form of book talk. And congratulations again on your very illuminating work, which was done in an unprecedented speed. And thank you, Kelvin, for the very insightful questions. Really, it was food for thought. And I very much look forward to hosting your own webinar in due course. I also want to thank Neil. Thank you so much for giving us your support from your center. CBFL hopefully will be a staunch supporter and collaborator with AIIFL. I think your center's history is very, very long. AIIFL also has a very long history, and so hopefully there will be more activities exchange and share by two centers. Without further ado, let me thank all of you, including our very, very attentive, very attentive audience. There were so many questions from you, and they were very interesting and informed questions. I look forward to hosting our next event. More details will follow. Thank you very much, everyone. Thank you.